Welcome to week 6. This week we cover the topic of policy exclusions from readings in your casebook, pages 172 to 192. The first case that we cover is Adams v. Toyota Motor Corporation. This is a United States Court of Appeals for the 8th Circuit case from 2017. So this is somewhat recent. We'll cover a few different policy exclusions in this lecture, the first being similar happenings. Some background from this case. This was a driver of a 1996 Toyota Camry who accelerated unintentionally and then caused a deadly accident. Family members of the deceased brought this product's liability case against Toyota. The plaintiff sought to introduce evidence of other similar incidents. You'll see this sometimes called OSIs, of other unintentional acceleration in Toyotas. The trial court allowed 3 of these cases, only having to do with 1996 Camrys. Other similar occurrences evidence may be relevant to prove that the defendants have notice of the defects, that they had the ability to correct these known defects, that they had knowledge of the magnitude of the danger, and that the products lacked safety for their intended uses or have knowledge of that causation. The quote comes from Levitt v. Union Pacific Railroad, and then this case also quotes another case, Hale v. Firestone Tires, by saying, "Evidence of prior accidents is admissible only if the proponent of the evidence shows that the accidents occurred under circumstances substantially similar to those at issue." The issue in this case was whether Toyota alleged plaintiffs failed to establish that these other similar occurrences were caused by the same defect, and therefore the district court abused its discretion admitting that evidence for the purpose of proving a defect. The holding in this case was that the similar incident evidence is admissible only if the incidents occurred under substantially similar circumstances. They found that the court here did find substantially similar circumstances and that the district court actually gave careful attention to this issue and acknowledged the potential dangers before admitting the evidence. As an aside, Toyota has faced a lot of litigation surrounding this unintentional acceleration issue. They've paid criminal penalties and fines for deceptive statements and hiding evidence of legitimate problems with their cars, and they've actually paid large sums to settle private actions. The next case we cover is Phillips v. Century LLC. This is a California Court of Appeals case from the 2nd District, Division 6 from 2017. This case is also having to do with similar happenings. For background, this is the opposite of the last case. So this case involves evidence of a perfect prior safety record for a product. We have a plaintiff who was sparring at a martial arts studio wearing Century headgear. He was punched in the face and then resulting in an injury that left him brain damaged. Century testified that they had sold over 100,000 units of headgear, and this was the only claim of injury ever made. The issue here is, did the trial court abuse its discretion in admitting Century's evidence of a prior perfect safety record? The court held that no, the trial court did not abuse its discretion. It emphasized that the evidence of no prior claims is probative in cases alleging negligence because foreseeability of its harm is an important issue. The witness testifying to the good product record had to be familiar with safety surveys and records concerning this product, and the court held that in this case, Century's witness was familiar. The next case we cover is Tour v. McDonald. This is a Court of Appeals for Maryland case from 1997. This case is dealing with the topic of subsequent precautions. For background, this was a medical malpractice action, and the jury returned a verdict in favor of the defendants. The plaintiff appealed and claimed an error in the exclusion of subsequent remedial measure evidence. Plaintiff's husband was scheduled for heart surgery. Before surgery, he experienced chest pain and was admitted to the hospital and given an anticoagulant. Hospital protocol called for the drug to be discontinued 3 hours before surgery. The husband's surgery was then postponed for 4 hours because of one of the surgeons had an emergency. And during that time, the husband went into cardiac arrest and died. After his death, the hospital changed their protocol so that the use of that anticoagulant could be continued up until surgery. This case is dealing with the Federal Rule of Evidence 407, which is excluding evidence of subsequent remedial measures to prove culpability, but not excluded when offered to prove feasibility or impeachment. So at issue here is whether feasibility was at issue in this case. Could the husband have continued to receive the drug until surgery, and therefore allow admissibility of this subsequent remedial measures? There's also the issue of whether the change in the hospital protocol was admissible to impeach the doctor who testified that continued use was unsafe. This court held that no, the hospital protocol was not admissible to impeach, and this was excluded under FRE 407, and that no, feasibility was not at issue at trial because the doctor's testimony was merely stating that at that time, defendants reasonably believed that restarting the drug would be dangerous, as opposed to arguing that now it was still not feasible to continue to give the drug. The court felt the doctor had made a judgment call based on his knowledge and experience at that time and had not yet experienced the problems from a case like the plaintiff's husband. So, as a question, what kind of testimony might have opened the door to impeachment for the doctor? A few options. So the doctor could have testified that that prior procedure was the best possible procedure and that it would be malpractice to do otherwise. This would increase the impeachment value of the change. The doctor also could have testified or implied that this procedure is still being used. It's like saying this is the way we do it at our hospital. We have 3 hypos in your casebook on page 187. Please be prepared to discuss these together as a class. The next case we cover is Davidson v. Prince. This is a Court of Appeals of Utah case from 1991. This case covers the topic of offers in compromise. As a background, the plaintiff sued a truck driver and the driver's employer for injuries caused by a steer that allegedly charged the plaintiff. The steer had escaped from the defendant's truck after the truck tipped over due to the driver's negligence. The plaintiff then encountered the steer a while later and was injured when he approached it. At trial, the defendant convinced the jury the plaintiff was cornered by the steer, making him at fault for his own injuries. On the issue of how close plaintiff was to the steer, the trial judge admitted evidence of a letter that plaintiff wrote to the defendants describing the incident. He stated he approached within 10 feet. At a deposition, the plaintiff had said 40 feet, and at trial, he had said 22 feet. In this letter, he also wrote, "You may speak with us directly, or we can send it to lawyers and to court. You decide." Plaintiff claimed the letter was part of settlement negotiations and thus inadmissible. So the issue here is, should that letter have been excluded by the trial judge because it was an offer in compromise? The court held that the letter was admissible. They held it was not a form of settlement negotiations and merely an attempt to inform the defendants of the facts of the incident. The letter demanded payment in full and actually said they would not compromise. So what if the letter had said, "I think this case is worth $100,000, but for this week only, I'll settle for $50,000. Would this letter then have been admissible? This would change the letter to be an offer in compromise. However, per this court's footnote, we can see that even if the letter had been an offer in compromise, it still would have been admissible to impeach the plaintiff's testimony about the distance from the steer. We'll then in class cover the hypos on page 191, so please be prepared to discuss together. And that is the last case we have for this week. Next week, we will cover the topic of hearsay, which will take up the rest of our semester's readings.